perhaps if we go straight to questions.
She did have very dulcet tones. She should get a job as you can get a job as a radio announcer. Okay, we'll start Poto with you. Do you have any questions for Mr. Bonus? Stephen?
Yeah, I've got a couple of things for that. At 24, you just noted I've been asked to consider blah blah blah. Who asked you? In terms of, like, you've been asked to consider whether the addition of matter E, I can't. We've read so much information, I can't remember whether we asked you to do that.
Sure. No, Mr. Chair issued 3 additional assessment matters.
That's what my colleague said.
Yesterday.
Double checking you were out of the room. I guess that you, in paragraph 30, you talk about the primary hazard zone, and I don't think there's any disagreement that there's a level of uncertainty still remaining in a number of areas. You've heard from the table that the key issue seems to be one of timing, and at what point would the panel have enough information to either recommend granting or recommend declining the plan change, and then leave the level of detail for the resource consenting or other process. So you've mentioned there the insertion of assessment matters post-rezoning is not, in my view, the more efficient or effective means to address such risk. I'm still at odds as to how, at what point does the panel draw the line and say, okay, we can make a decision to grant or decline at this point here. Say, for example, the geotech.
Yeah, look, it's a really good question, and it's certainly one that I've grappled with as well. I think with everything else, there is material on the table for the panel to make a merits-based decision on things. There's an unknown around geotechnical hazard. The view of Ms Phillips for the council and my interpretation of policy 13.1, 13.2 in the Waikato Regional Policy Statement is that that's not a matter, or the risk is not a matter that can be left after the fact in terms of zoning. Those provisions in my reading of them are proactive. It's about addressing natural hazard risk and not developing in areas of natural hazard risk or intolerable risk, sorry to use that phrase. So it is a difficult one, and it's the only one I think where there is a specific gap in terms of you've got 2 views, and both geotechnical witnesses agree that analysis needs to be done. It's just when. The view of Ms Phillips and myself, reading proactively into the regional policy statement, is that it should commence before zoning. The proponents justifiably have identified that there is a substantial amount of investigative works that needs to be done, subdivision and everything else, and actually give us certainty, and then we can do that. So my overall conclusion was, given the other matters that I've identified that there is viability on, there's a question about demand, consumer demand and efficiency of infrastructure. But if the panel determines that the Section 42A report overstates that or gets it wrong, there is the ability to provide some certainty to the proponents with rezoning through an interim decision and getting more information in terms of those investigative works, which hopefully would address that issue as well.
So, in terms of going back to geotech, if for example, I'm just testing the feasibility of this in terms of time frame. If, for example, the decision was made to grant the plan change based on the known geotech information, there seems to be an acknowledgement that there is a degree of geotech risk there, and that there are largely well-known engineering solutions within this region that should address those issues, should not would. And so does that then leave the risk still with the proponent, that at the next phase there is that detailed assessment and it's found out that those risks are, those hazards are too live and unable to be mitigated, so therefore they can't build in that area, or is my thinking wrong there?
No, look, it's a fair and reasonable question. The issue around can that risk be accepted by the proponents is correct, but it's only correct in part. The council has to administer and develop its plan. If it's found that there is risk and that risk is intolerable, there's a question mark as to what the council does with the zone that's there. There's also a question, but again it goes into mitigation, and I think both Ms Phillips and Mr Hashard have spent quite a bit of time usefully providing this information to the panel, that there's a range of costs in terms of addressing those issues. And if they're straightforward, those costs aren't particularly high. If the hazard risk is substantial, then those costs in terms of developing the site would be substantial, and the ability to actually manage stormwater through the pumice soils in particular was one that I think that both Ms Phillips and Mr Hashard identified for the panel as being of particular concern. So yeah, your question's right, the risk does lie with the panel, but there is also an issue for council in terms of what does it do with the zone if there's an issue.
You did, in paragraph 33, you talked about such a decision could be tempered through either an interim decision or deferring zoning in conjunction with the triggers identified, and then you put 14. Is that a correct? Is that paragraph 14 in here?
Oh, sorry, it should be 15. It was late at night when I was typing this up last night. Sorry, sir.
Yes. All right. For my benefit, is an interim decision or deferred zoning, is that a kind of soft yes or a hard no or what?
No, it's simply an option. The legality, I think, of a deferred decision is probably a difficult one as well, because it's certainly not what the proponents have asked for. The issue that I'm wrestling with is the proponents have now provided enough information to give the council sufficient, the Section 42A officers sufficient assurity that there is a viable zone that could eventuate, and that there is a package of measures that could be done to offset effects associated with both development of the plateau, but also the mechanisms could be in place. It's not necessarily that they will be able to actually develop infrastructure and connect with those. So the two issues I'm left with are the demand efficient provision of infrastructure, which is the evidence of Mr Osborne, and I've applied that to the framework, and this one around geotech. There's a merit-based decision that the panel can make in terms of the efficient use of infrastructure and demand, but there's a question mark around geotech. All the interim decision would do would be to provide some assurity to the panel that if they agreed that demand wasn't an issue, but the geotech one still was a question, it would provide a bit more certainty to the proponents prior to agreeing and settling with the zoning on the site. It would allow a little bit of time to get that investigative works done, but it would provide the proponents with a lot of certainty that all the other merit-based stuff is behind them.
Thank you. Last question from me was, you've included an attachment A. I haven't done a line by line of a previous version. Did you want to talk us through that, please?
Yeah, just briefly. One of the things that was raised in the rebuttal evidence, and also some of the discussion yesterday around the provisions, were around certainty and the ability for some degree of preciseness and ability to ensure that the appropriate, that the outcomes that are specified in Appendix 8, and there's now certainty as to what they are, can actually be followed through. So the suggestion with the amendments to the policy, which at the moment simply records that development should be generally in accordance with the outline development plan, should be strengthened, in my view, to actually refer through to the outcomes that are specified, and they're actually identified in Appendix 8, so I'm not generating anything that's not already there. And the reason for that is twofold. One is, if there is a breach of 4A 3.2, I think it is, 4A 3.1, the development goes to a restricted discretionary activity if it's not in accordance or general accordance with the outline development plan. And the only provision that you can look at is the one that says development should be generally in accordance with the outline development plan, which doesn't actually take the council or the proponents very much further in terms of what are the appropriate outcomes we're actually trying to measure the change against. So that's the reason for the amendments to the policy. I agree with the additional matters that were provided by the panel chair yesterday in terms of the controlled activity status for subdivision that was in accordance with the outline development plan. The concern that I have with a breach of the outline development plan is that there's now 13, 14 assessment matters covering a massive range of things that would be looked at as a restricted discretionary activity. And I think it would be far more beneficial to the council, and in terms of certainty, in terms of outcomes, that was a discretionary activity and that it was tied back to the policy that I suggested. I fully put out there that there's probably a number of ways to polish or reword that, and presumably the proponents will be taking an opportunity to provide feedback to you on how that could be done. But that's the principle or the rationale for those changes. So essentially it's more depth and colour to the policy, and a change in status from a breach of accordance with the outline development plan to a discretionary activity rather than restricted discretionary, simply because of the plethora of matters that were then put forward.
Thank you. That's all from me.
Right, I have just a couple of questions, Mr. Bonus.
Mr. Whareroa.
In paragraph 33, the second last one of your outline here, you said the recommendation falls to two matters, economic costs and geotechnical confirmation. In terms of economic costs, by that are you referring to simply the infrastructure costs, which have been identified in the evidence of Mr. Osborne, or are you looking more widely at the economic costs and benefits of the pattern of urban growth which would be enabled if this proposal was approved?
The latter, sir.
So it's the whole.
It's the demand, supply, and the economic considerations around that. Essentially the evidence of Mr. Osborne.
But he did acknowledge that he hadn't looked at those wider issues in terms of the overall patterns of growth. He'd focused on the infrastructure costs, and that's what he identified in his analysis.
He did, but he wasn't silent on those. My understanding was that he also provided discussion and analysis around the extent of supply and the transfer of those benefits and costs as a consequence of an oversupply in the market.
Okay, yes, I accept that. It was about the supply and demand in the southwestern area, and I accept that. It was, but the issue that I did put to him in a question was whether he had taken into account, if you like, the with Whareroa versus the without Whareroa outcome, and he acknowledged that he hadn't looked at that.
He conceded that he hadn't, yes.
So he hasn't, he didn't look at that. And so and when you're looking at economic costs, are you looking at just the scope of Mr. Osborne's evidence, or are you looking at it in the wider? The wider issues of economic costs and benefits, which would have presumably been covered in the work on the TD 2050.
There's quite a lot in your question, sir.
Sorry.
I don't think that Mr. Osborne was quite, and again I could be wrong, but my understanding was that he wasn't silent in terms of what those economic costs would be in terms of the southern bays and an oversupply of land holdings there. What he did agree to was that he hadn't done an assessment, an economic assessment of a with Whareroa and without Whareroa, but my understanding of his answer was that that was on the basis that there was already an oversupply in the market, and he just saw that as a net transfer from one zoned serviced area to the new development. So I don't think he was silent on it. But again, that's my understanding of his response. I could be wrong, but in terms of this, it's in relation to those broader economic issues.
That he's covered on his evidence.
Yes.
Okay, thank you very much.
Just a couple of matters focusing on the geotechnical issues first. And just come to your paragraph 30 and this issue of intolerable risk. Now the RPS does not define what that means. And I put that to Mr. what's his name now?
Mr. Hashard?
That's the one. That's his first name though, isn't it? Or is it? Mr. Fadness.
Mr. Fadness, I apologise for that.
And he wasn't really able to help there either. Now, I've recently chaired the hearings in the Bay of Plenty Regional Council area for the Whakatane District Council. It was a combined hearing where we looked at the Matata debris flow and the extinguishment of existing use rights for residential activities within that debris zone. So it's an interesting case. In that case, intolerable risk was defined, and it was defined as a 10 to the minus 4 or a 10 to the minus 5 risk of death. So intolerable risk, based on the case I'm familiar with, is that there's a 1 in 10,000 or a 1 in 100,000 chance in any given year that someone will die from the natural hazard. Based on what you've read so far, do you think that level of risk exists at this site?
I'm the wrong witness to ask, sir, but I guess
Well, the answer
I don't, from reading through the geotechnical material, get the sense of risk at being at that level if you were going to appropriate the definition that you have to this particular site and this particular regional policy statement.
Yeah, and the regional policy statement, I mean, it's fault because it doesn't define what that means. So I've had to go to other cases that I am familiar with. You put a lot of emphasis in your presentation to us on RPS policy 13.2, and that policy, and the words are important, aren't they, in these statutory instruments? That policy starts off as subdivision, use and development are managed. It doesn't start off with the words rezoning proposal should be assessed by, or the zoning of land is to be managed in accordance. It's focused on subdivision, use and development, which makes me think that this policy is more targeted as subdivision resource consent process than a rezoning proposal. Do you have any thoughts on that?
Two thoughts. One is that they're obviously inextricably linked.
Mm-hmm.
There is a need for the panel to turn its mind to if the zone change would occur, is it effectively defeated by ultimately something that occurs later? Also, policy 6.1 refers to the principles of 6A, and there's been a lot of discussion around all of those.
Yes.
I think it's H, but I could be wrong because it's not my region where I live, but that does talk about reducing or not developing areas around natural hazard risk at the time, and that provision is specifically focused in terms of plan changes and urban growth. So, sorry, I haven't answered your question particularly well. I think the two are inextricably linked. I take your point that this policy is very much framed around we're developing something that's already there, but I don't think that the panel can necessarily not make not satisfy itself that it hasn't addressed those particular matters in terms of hazard risk.
Sure. And just still dwelling on your paragraph 13, you said you didn't have enough information for you to confirm that the site's not in a primary hazard zone. Can you remind me what the definition of that is within the RPS?
No, I couldn't, sir. I can look it up.
Well, I can look it up myself as well. I just thought you might know. Nor that the residential development of the land will create intolerable risk, and we just explored the fact that the RPS doesn't define what that means. But when you wrote that paragraph, which particular geotechnical hazards did you have in mind that you thought might, or you weren't sure would not create an intolerable risk? Which hazards did you have in mind?
No specific hazards. I was essentially relying on the evidence of Miss Phillips and also Mr. Hashard that identified that there was further hazard investigations to be done for a range of ground hazards. And primarily the evidence of Miss Phillips that there should be some investigative analysis done first and foremost to identify whether that hazard risk was there to an extent that would undermine rezoning.
Okay, so you didn't do the type of assessment where you might go volcanic risk, no, flooding risk, no, seismic risk, no, erosion risk, maybe. You didn't do that kind of analysis?
No, sir, that's not my expertise, and that's not the way that it was provided in terms of the evidence provided by Miss Phillips. I know that the proponent's geologist has done that in terms of a tabletop exercise,
Yeah.
and has provided that for the panel.
Yeah. I must say I was a little bit disturbed to hear from Miss Phillips that she only, it wasn't until this morning that she understood that the access road required a separate resource consent process, so she's obviously been thinking that the whole thing is part of the rezoning proposal, which is a bit disturbing. But
Well, her answer will have to stand, but
Exactly,
I mean, it's been discussion.
yeah. All right, so now just in terms of these suggestions here of an interim decision or a deferred zoning, I take it from your answers to Commissioner Wilson that the interim decision would be interim insofar as it only related to geotechnical matters?
Clearly, that would be based on the panel obviously overcoming the economic issues. But yes, the only residual issue would be in terms of geotechnical investigations.
And deferred zoning, and you raise the issue of scope, which I think is quite relevant because that's not what's been applied for. But in terms of a deferred zoning, would that then require a further plan change to become an operative zone, or would it automatically become operative if these geotechnical issues are resolved?
It's one I've been giving a lot of thought to in terms of where the Section 42A report could potentially go. And it was a matter that was front and centre when we were dealing with the Maori roadway in terms of a trigger and dealing with that. There are examples, I'm aware of at least one in Christchurch around a reserve swap and a golf course, where essentially there was a time frame put to the zoning on the basis that a number of triggers which were outside the control of the proponents and also the council could be undertaken within a certain period. It gave the landowner certainty that if they managed to achieve those things, then effectively the zone would happen. But after a period of time, the zone would dissipate.
So this would be the opposite of that, would it? Or?
No, this would be effectively on that basis, so that if the panel were of a mind to approve, the zoning would be provided on a deferred basis, subject to the triggers that it thought worthwhile. I've outlined what I think they are, the Maori roadway and the geotechnical issue, and the consent framework in terms of the roadway and the bridge. And if those matters were resolved by a certain time period, then the zone stands and away you go, because effectively you've got all the mechanisms that you'd need. There's certainty and a surety that the zone can actually be enabled and developed, and away you go. If for whatever reason one of those mechanisms which are outside the control of the proponents or the council isn't able to be done, the zone effectively dissipates after a certain period of time. But the proponents have clearly not asked for this. I'm just... Again, code of conduct, just trying to explore in my mind and outline for the panel, are there ways that these matters could be overcome?
No, sure, that's fine. And so just to be clear in my mind, so in terms of the rule structure, should we decide as a panel that the rezoning should proceed, or should we decide to recommend that it proceed? Need to get clear in my mind what our decision-making delegation is. You're recommending that if remain controlled activity if in compliance with the outline plan, but otherwise default to full discretionary.
That was on the basis of the Appendix 8 amendments that were provided in the rebuttal evidence of Miss Lewis, which identified a substantial number of new matters for a breach of the outline development plan and also for controlled activity status. And the additional matters that you added yesterday, in my view,
Sure.
putting those two things together, the breadth of discretion was so substantial that it made restricted discretionary effectively not the most appropriate provision.
Right.
And also the other benefit of it is that it is not arguable that there are other policies that can be brought into play in terms of landscape and also indigenous vegetation and archaeology to be looked at if there is a breach of the outline development plan.
Sure.
Effectively a belts and braces, sir.
Yeah. So it's essentially what you're saying, and correct me if I've got this wrong, that for the controlled activity status, it's important to take belt and braces and have a very long list of matters of control so the decision maker is not fettered.
Yes.
But once you no longer qualify as a controlled activity, the matters of discretion would be so long in a restricted discretionary activity that the question is why bother, just make it full discretionary.
Yeah, that's certainly part of it, but the other part, and I'm aware of this in terms of sort of wearing my consents hat, is that it's arguable if I breach one rule as to whether or not other policies become relevant.
Sure.
And as I outlined at the beginning of the statement, this area is overlaid with Section 6. It's very much, whilst there are viable options in terms of dealing with landscape and indigenous vegetation, it's by no means straightforward. I think the council experts have made that reasonably clear. So I guess the more certainty is that those matters can be considered, the better.
Great, that's very helpful. Thank you. Let's check with the panel. Any further questions arising for Mr. Bonus, who's commonly known as the sweeper, because he's the planner, but it's his job to pull together the streams of technical advice. So it's very good. Thank you very much, Mr. Bonus. No further questions for you.
Thank you, sir.
Now, Mr. Winchester, what, if anything, are you going to tell us?
I've got a few points to make, sir, with your leave. They do address some questions raised today. They do relate to matters I've covered in legal submissions. A few preliminary matters just to tidy things up. You've asked a couple of questions. I've checked your delegation. I believe it's to hear and determine. That certainly is recorded in your procedural minute 1. It indicated that that was the council's intention. I don't think at that stage the delegation had been made, but that was what was intended.
I'll just be a little bit pedantic about that. So we make decisions, because primarily a plan change hearing is about making decisions on submissions. So we make a decision whether or not to reject or accept each submission point with reasons. So that's a decision-making delegation. I'm looking for you to either nod your head or shake your head. Yep, so that's that one. But in terms of the wording of Appendix 8 and the wording of the district plan rules, is that a recommendation delegation or a decision-making delegation?
I'd need to check the terms of the delegation, sir, but I don't think there's a distinction.
No distinction?
I understand it's a determination on the merits, including the wording of the plan change.
Okay.
So you're not wearing two hats, as it were, to accept or reject submission points and then make a recommendation on the fundamental merits. That would be a quite unusual delegation. I haven't been asked for advice on it, sir.
Yeah.
but I'd be surprised.
Okay.
Perhaps Ms Samuel can just double check that.
Yeah, I just know that sometimes the wording of delegations aren't as clear as they might otherwise be.
Indeed.
Okay, cool, thank you.
I was interested, sir, in your interchange with Mr Bonis about intolerable risk and what the regional policy statement says about that. My understanding, and it's informed from my role in the Christchurch replacement plan process to do with rockfall hazard on the Port Hills, is that it is for the community to determine what is tolerable risk, and those numbers you've talked about, 10 to the minus 4, 10 to the minus 5, from a risk expertise perspective, they are sort of the classical thresholds that are recommended depending on the nature of the hazard. But possibly the reason why the regional policy statement doesn't specify a number is because it will leave it to individual communities through the district plan to determine that tolerable risk for each hazard. So maybe that something, a gap or an issue for the district plan, but it remains at large, and I guess you need to consider what evidence you have before you as to whether there is a life risk and whether it is intolerable or whether it can be managed. And I suspect the point there, though, is an interpretational one around what the district plan intends and the regional policy statement intends as to whether you need to satisfy yourselves about that prior to rezoning, or you can essentially exercise a judgment based on the preliminary work you've got.
Sure.
Does that make sense?
No, that's fine.
Yeah. I can answer questions if you've got them about the concept of a deferred zoning, but I'll leave that now for the moment. So, having arrived this morning, it's been interesting to watch the interchanges, and I think very helpful, sir, when you put a question or a position to Mr Osborne prior to lunch about where you'd got to, and you sort of boiled down the thinking. And it was to the effect that you were looking at the council documents on their face and seeking to apply them on their face, and in my submission that is the correct thing to do. I'm not going to tell you you can't approve this plan change, but I will give you some advice, sir, around matters you need to satisfy yourself around in terms of the proper interpretation of those documents. And I suppose the first point, you indicated that, as you saw it, TD 2050 had retained Whareroa as in 2018 as a growth area. It was also reflected in the Southern Settlements structure plan. The district plan identifies it as a future urban growth area, and the question you posed was, why has the council done this? It's really not a question of if, but when. An important point, I think Mr Bonis identified it to you, is what TD 2050, the 2018 version, actually says. It doesn't, if you read it carefully, it doesn't endorse Whareroa on the merits. It had originally omitted it, and that's clear from the record. It was gone from the refreshed version when that was put out for public submission. It has kept it in to be considered on its specific merits. So what it hasn't done is foreclosed Whareroa. It's left it in on the basis of fairness because there was a live plan change request, nothing more. So I would suggest some caution in, you are required to place relevance and weight on TD 2050, but you need to be careful about exactly what it says and what it assumes at this site. So that, and that to an extent is, in my submission, important context. So I think it is an oversimplification, sir, to suggest that it's not an if, but when. The planning documents are also very clear about the how. How is this urban growth area to be advanced? And that's where some care is also required in my submission. So, dealing with the district plan, I have had involvement in TD 2050 from the outset. So TD 2050 and the following plan changes date back to about 2005, 2006. I've advised and acted for the council through the Environment Court on all those matters and the growth management plan changes. So it was one of the first district plans to take a very conscious and carefully structured and directive growth management approach. And what looked quite directive at the time is now actually reasonably orthodox and not as strong as it potentially could be. But in terms of what it intends and what it actually does in my submission when read correctly, and I'll cut to the chase here in terms of the difference between the council's 42A team and the proponents. It appears to be a considerable gap in interpretation of the planning documents as to what they mean. In my submission, the district plan is very deliberately not a market-led approach. It intended to avoid not just ad hoc development, which was occurring across the board around the district at the time. So new urban development was being proposed in a lot of different places. But the plan also turns its back on development capacity where it is not required. So what it did and what it does on its face with the urban growth areas is says, if there's going to be new urban development, it's here. So it provides certainty as to where. It's not a matter of when. It's not just a matter of when, because it may be never. So that's the first important point. And the second is that it's the how, which is actually really critical. And that's around the whole necessity and the questions you put to Mr. Osborne. So I've already identified why, from a TD 2050 perspective, Whareroa has been identified in that document. And that's context to the future urban zoning here. But there is a threshold for the proponent to cross. It's not just a fait accompli or a box ticking exercise. So from a council perspective, I would submit that it understands how it's planned and how its plan is intended to work, and what it says on its face. And I infer from the questions this morning that there's an inclination to approve the plan change, and Mr. Bonis has agreed that there is a basis for doing so. But in my submission, you need to get the analysis right, and that's the purpose of what I'm taking you through. Now, I'll come back to the how issue, because in my submission it is important, and Mr. Bonis has identified two examples of how the plan changes are being advanced, which create question marks. I want to address the environment Waikato involvement, and you gave the environment Waikato witness a bit of a hard time this morning, sir. And in my submission, I detected, when I understood the Environment Waikato evidence that they were here on a reasonable basis, and simply that if the district plan is not interpreted and implemented properly, then it in turn impacts on the integrity of the regional policy statement. And I think that's an entirely fair basis to appear before the panel. You made a reference to the Kaiapo Bay matter, which was a resource consent, and in my submission, quite different from the present context. I mean, it was so far beyond the bounds of the plan in terms of what the plan intended that really it shouldn't have been a matter that Environment Waikato needed to turn up and supervise. Now, if I can turn to part 2 of the Act, and this takes us back to the respective legal submissions which have been filed by myself and by the proponent's counsel, Dr. Forrett. And my fundamental submission, sir, is that on the basis of very clearly established case law and Supreme Court authority, which is the King Salmon case, it is only in the case of uncertainty or gaps in incompleteness or invalidity with the planning documents before you that you are to have recourse separately to part 2. And I haven't seen a suggestion that the district plan or the regional policy statement have any of those features that enable you to separately have recourse to part 2 of the Act. And my learned friend Dr. Forrett has suggested that you are required to use part 2 as a lens through which you consider the evidence and the issues. With respect, that submission lacks any authority. That certainly that overcomes the Supreme Court's decision in King Salmon. So, in my submission, you are required to look at the district plan on its face, determine whether this plan change request achieves the settled objectives, and that is very much the same as give effect to, and the same to the RPS. So I think I've covered that in my legal submissions, sir, and I simply say that I stick by what I've said there, and I prefer my analysis and interpretation to that of my friend. The final point I want to address is around this question of level of information, level of certainty, and how the plan change has been advanced. I think Mr. Bonis and the Council 42A report writers have given you evidence around what is new and what is different. They've also made assessments based on adequacy and whether things with the information now provided is satisfactory. The first point I would make that in terms of what has been asked for by the Council through the process, all of it is based in Council policy or the district plan. So documents like the Southern Settlements Structure Plan, TD 2050, and the district plan say that you can have plan changes for new urban growth areas, provided you do these things. And information about things, including the road access, is expressly referred to. It's not a mystery. It hasn't been plucked out of nowhere. It's front and centre. So if an applicant chooses not to address it, or they wish to carve it out of the plan change, or have it addressed by resource consent, so be it. But and bear whatever risk they wish to as a consequence. But by the same token, the Council cannot and should not be criticised for asking for that information. There's some irony that the Council requests, and indeed the evidence that it's produced through this process, appears to have got the proponents near to, indeed over the line of adequacy in many respects. So, look, that's a good thing in terms of the information before you, because it will mean a better quality decision. The question mark that you will need to satisfy yourself about in terms of that new information is the scope issue. And I've addressed that both in my initial memorandum, which was in the 42A report, and I've referred to it again in my subsequent legal submissions. And the tests are reasonably clear. They're entirely fact dependent. You don't have a lot of submissions and submission points to hang your hat off. And in my submission, you don't have a broad and unfettered discretion to make changes, so you will need to make a determination as to whether new information or new elements of the plan change request now before you are within scope and don't raise unfairness issues. So that's the end of my lecture. Thank you, sir.
Thank you. We'll see if we have any questions. Roseanne, any questions? Okay. Doug, do you want to move to you then?
No, I don't have any questions.
Got to me quicker than I thought. Hold up a sec. You may have already covered this in your discussions about Part 2 matters. Just reflecting on there's various references throughout the documentation we've been provided with regarding Section 6C 7A 8 and the regard to which, or the weight that we should give those matters. I think that both the proponent and the council team agree that that's whatever weight we give it, it's not the only matter to consider, and I don't think there's any disagreement there. At paragraph 30 of your submission, you state that neither of the more specific provisions in Section 6C or 7A are relevant when taking the treaty principles into account under Section 8. The proponent has, my words, appears to have taken some exception to that. And in fact, no doubt you've been briefed that yesterday Mr. McKenzie got up and we saw it ourselves on the site visit that the streets are named after Turangi Tukua and Ngāti Parekawa and Anipatena, which if that's the street I'm thinking of as a former chair and so on. So the cultural importance appears to have been divorced in some way from the fact that this is the proponent is the landowner is looking for some sort of economic gain. But Mr. McKenzie in particular made the point that that's part of them, in their view, implementing their kaitiaki responsibilities. I'm almost submitting myself. I'll get there in the end. Hold up a moment. So, do you still? I guess the complexity here is that the proponents are the landowners. They are mana whenua. In fact, the local hapu has submitted to that effect through Kia Paranahi, submitted to that effect, and so they're both the developer or proposed developer, and they are tangata whenua. I was surprised then to read that that Section 6C, 7A and so on is not relevant, but I might have been taking it out of context. Have you changed your view in that regard?
No, I haven't, sir, but when I wrote that, I had understood that the specific land for the plan changes was not ancestral land. So I don't know the answer to that. I hadn't understood that was advanced. Certainly accepted as Māori owned, and there are strong issues of tangata whenua self-determination and aspirations around that. No dispute whatsoever. The only issue there was whether, because Section 6E is reasonably specific in what it talks about as a matter of national importance, which talks about ancestral land. If it is the case that it's ancestral land, I'm not to dispute that. It was simply based on what had been advanced. I did not understand that to be the case. The issue with sections 7A and 8 then is a little bit, it's difficult to reconcile with the other case law which says if your plan is settled, then you don't go and have another look at Part 2 of the Act. There is the potential for an argument that to the extent that the relevant provisions of the plan and policy statement don't expressly address Section 7A, kaitiakitanga, and 8 treaty principles matters, that you might be able to say that, well, that's a gap, and we'll fill it with evidence from the proponents, and that is available to you. So I'm not ruling it out. I'm just telling you what the law is.
Thank you. That's helpful. I was just trying to get it all squared away in my own mind, so I appreciate that. Thank you.
Yes.
No further questions.
Kia ora, can I just add that that was a question that I directed this morning to one of the witnesses. And the regional policy statement is at the method 618. It's almost a direct cut and paste of Part 2. And the wording is exactly the same. So I can't see how you can separate. You know, it's up there at Part 2, and you've given your argument to where that sits, but it is now repeated down in WRPS in that method. So that's another, I think, needs consideration.
No, I'd accept that. Yes.
Got myself sorted now. I'd just like to refer back to your legal submissions. In there you talk, I think it's in points 17 and 18, you talk about, in essence, that it's not as simple as approving a new residential zone and sorting out the detail later, because it seems to me that a lot of the discussion is about the order and sequence of events. But I just wanted to expand on the point in 18 where you talk about if the land is rezoned, council would come under significant pressure to approve and come up with solutions, because it would otherwise be seen as contrary. Could you elaborate on that?
I can give you an example. So we've had an interchange this morning with between the witnesses and the panel around the issue of the road and its consequential effects. And the chair of the hearings panel has been very clear that it's an excluded matter. It's to be dealt with as a discretionary activity, as a resource consent. If, assuming the plan change is granted, you'll have an area of residentially zoned land which needs to be accessed. It will be accessed, intended to be accessed by the road connection. That road connection traverses some Section 6 resources, landscapes, biodiversity, native vegetation. When you think about the case law around Part 2 of the Act, it has the potential to diminish the weight given to those Part 2 considerations for the resource consent, because if you've already got the plan change, you say, well, the plan change needs to be serviced. So it needs to be serviced by this road. We've already anticipated that there will be a road. So Part 2 matters, in a way, we've sort of really, we've thought of them. They're not in the plan change. We've thought of them, we've turned our minds to them, but they're not going to be an obstacle. And so if I was acting for an applicant, that's what I'd say. And if I was acting for the council, I'd say you've got yourself in a pickle. So that's why the election to exclude the road and its effects and the uncertainty created by that is a critical point.
Thank you, Mr. Winchester. No further questions from me. So that's the end of the 42A team's report to us.
Thank you, sir.
Thank you. So now, Dr. Forrett, in terms of the applicant's or the proponent's reply, I think in earlier communications you've indicated that you may well do a verbal reply now and then also supplement that with a written reply later. Is that still your intent, or do you wish to just reserve everything for a written reply later?
Actually, Mr. Commissioner, to be quite honest, I prefer just to do the oral reply. It's no surprise to you that our clients are facing huge costs over all of this,
Right.
and to spend more time for me to sit down and another couple of hours of replying. There's not a lot of new stuff, so if I can have a few minutes, because there's been
Sure.
the discussion about the proposal for the deferred zoning, and also the additional policy that Mr. Bonis has suggested, and it'd be good to have a talk to Ms. Lewis about that.
Sure, so would you like 20 minutes, 30
Yep,
minutes?
that should be fine, thank you.
20 or 30 or which?
20 minutes will be fine, so long as the panel's happy for me to go in my highlighted order rather than
Sure.
putting together any semblance of actual structure to this.
Yeah, sure, and if you need more than 20 minutes, just let us know.
Thank you.
So we'll adjourn now until 3:35. Thank you.
thought I'd just start with the various different planning documents and so forth. And just note that the district plan requires there to be a structure plan in light of the TD 2050 document. And policy 611 in the RPS talks about growth in Taupo district being recognising TD 2050. Now that was the pre-2018 document. So that RPS policy is about the one that doesn't talk about there being a look at demand. And it also talks about development being as per any subsequent adopted structure plan. And there is an adopted structure plan, and the only adopted structure plan that is in place at the moment actually says that the landowners decide what the market demand is and when to make those decisions. So at the very least, there seems to be a bit of a conflict there, but it does seem a little bit ironic to, on the one hand, spend a lot of time and evidence playing down the effect of TD 2050 and the structure plan, but when it suits, to refer to the refreshed version of TD 2050. In my submission, we have an adopted structure plan that contemplates development on this site, and it says that that the landowners get to determine, and even the refreshed TD 2050, any extra clause that got put in there is only really in relation to demand. It's not in relation to other things. There was always an expectation that the merits of the plan change would be considered as part of this application, and in my submission, the proponents have gone about doing that. I also listened with a lot of interest to Mr. Drayton's submission, which was really given from the heart and with passion, and I thought he articulated exactly what it is that's unique about Whareroa, and it didn't put him off buying there. The moment a section became available, they were in. And they bought it. And to me, that says everything about demand, really. Regarding Ms. Foley's evidence, I spoke to Mr. Mackenzie about this, and he made the point that it was interesting that Ms. Foley began her evidence with a pepeha in Māori, and then when put to it in terms of her understanding of a policy within the regional policy statement, that pretty much just is Section 6E, it was outside of her expertise. And if that's so, then it's pretty concerning for a senior policy advisor for the Regional Council. there was no evidence from anyone that suggested that there was any likelihood of a risk that would be intolerable or that couldn't be mitigated. All of the witnesses agreed that there was either mitigation or to the extent of ecology, potential for offsetting. And that includes those kinds of effects that could be intolerable. And the Regional Council didn't provide any expert evidence, although a lot of the things that Ms Foley referred to as being very significant for the Regional Council, unlike Heritage New Zealand, which also put a submission in opposition, they didn't get experts on any of those areas, which I thought was odd. And Ms Phillips made the comment that her recommendation that there was insufficient evidence really came out of those guidelines, that the guidelines hadn't been followed. And I agree with her where she commented that they are just guidelines, but they're guidelines that their professional body has put in place, and in normal circumstances you would look to follow them. But what's interesting from her comment there is that the investigation that she put forward in her evidence as being appropriate or being enough to satisfy her was going to be one hole being drilled. Now, that is not consistent with what the guidelines say should be done. And the investigation program that was attached to Mr Panis's evidence, which Ms Phillips agreed with, that outlines what the guidelines should be done, should be done, and is the proposal that would happen as part of that preliminary stage. In terms, Mr Shaw just made a comment about the availability of the offset planting, and whether there can be security in terms of ownership for that. And in my submission, that's something that the landowners have to deal with in exactly the same way as in any other proposal where offsetting is required as part of a resource consent. It's over to you to find out where that can happen and to make sure that it can be secured. In this situation, we've identified land that's available close to the proponent's land. It's in the ownership of Whareroa Station, which is a related body. There's no reason to consider that there wouldn't be access there. But again, that's our client's risk in my submission. Mr Osborne seemed to be suggesting, when he was talking about the way in which he'd calculated demand, that there wouldn't be any demand in the district for the next 40 or 50 years, where he was talking about those infrastructure costs into the future, and when he was asked about those infrastructure costs, and I just thought I struggled with that because I can't imagine the district refusing any new greenfields subdivisions or refusing to do any rezoning for the next 40 or 50 years because of the existing demand and the effect that that might have on the efficiency of the infrastructure and the associated costs. Maybe I misinterpreted what he was saying, but that seemed to be quite a big call. And there was quite a bit of discussion about the other areas that might lose out. And all through this, there seems to be, and in the original property economics report, there seems to be a weighting towards other areas, and initially even areas that weren't rezoned, against this land. And in my submission, you can't compare this land with the areas immediately around Taupo or even Kinloch because it's different and it's never going to be servicing day-to-day people living in this urban area. But also, the other part of me says, even if it was, why is there an assumption that other land should be preferred over this? This is land that's been identified as a growth area, and it should have the same status or more status than other areas that haven't been so identified. Looking at the reserves issue and what to do about the pathway, raises a few questions actually, because the pathway is also proposed to go through the SNA, and the SNA isn't going to be owned by Taupo District Council. So, and there wasn't an issue raised about that being in different ownership from the pathway. There presumably isn't an issue about pathways going through residential areas in the town where the people on either side of those pathways are different private landowners. That doesn't seem to be a problem with the pathway being in council ownership. There was a sort of a veiled suggestion that, or even not so veiled, that the Maori reservation land wouldn't be looked after as well, and I think that was almost explicit in Mr. Murray's rebuttal evidence. And offence is taken to that. In terms of what to do with the bit that's through the bowl, the reason why we had it going through the bush was to give the residents a nice little walkway through the bush, and much the same as they had a continuity of what they would have had coming up through the SNA. So, I mean, that was there. If the council wants it to go outside of the bush and go along the edge, then that's fine. In our view, that whole issue can probably be sorted out at a resource consent stage, but we don't think that it could be, you could vest that bit of the walkway in as Maori reservation, because that would be complicated if you were going out of one area of walkway that was vested in the council and then into another bit that was vested in somebody else. So I think that would be problematic. So whatever happens to the walkway, it probably needs to stay in the council's. But really, if a tree falls over a piece of your land, then the same as anywhere else, you can go in and get a chainsaw and cut it down to the extent it's on your land. So not sure why that would be a problem for council maintenance. Also unclear as to if Mr Hadley gave Ms Campion the instructions about what the council does and doesn't want. I'm unclear as to why Mr Hadley wasn't here giving evidence to the panel. The proposal from Mr Bonis in terms of the revised policy, that's okay, except that the wording to Roman 4, we, assuming that the scope for this revision to happen, and in my submission there probably is, to be fair, Roman 4, we would want the last few words to be amended so that it would read landscape and natural character are avoided, remedied, mitigated or offset. And there shouldn't be any particular weighting. Where we would oppose the change in status from restricted discretionary to discretionary, and consider that if there are a large number of conditions that, or matters that can be considered for the purposes of a controlled activity consent, we don't see why council officers wouldn't be able to manage a wide range of matters to consider as part of a restricted discretionary consent and have confidence that that assessment could be done. It's a relief to have got this far into the hearing and to find that the Section 42A team is now comfortable that that there is enough merit that the plan. We're not comfortable with a deferred zoning approach. First of all, I think there really is an issue with scope there. But more importantly, it's the uncertainty associated with that, and not just the geotechnical investigations, because that might be some months or years away. That will be an expensive undertaking, and it's going to take the incorporation time to sort out how it's going to proceed with that. But also, Mr. Bonis tied to that an agreement regarding the bridge. And while we're really, I think, on track for getting agreement as to something that records the aspirations of the parties, and there seems to be general agreement, and there's been good work on that in terms of pinning down what those aspirations are, and there seems to be no disputes about that. It's what might be seen as being required to bed down any further agreement. So if it was just something that recorded those aspirations, I would expect that the parties can sort that out in the next week or so. It's not difficult to put an agreement around that. But if that was interpreted to be actually getting the Maori roadway confirmed, then that is something obviously that would need a lot more input, and the trip to the Maori Land Court, and I think that would be a problem in terms of timing. And we have previously said that the incorporation is proposing to bundle together a number of things as part of the one application. Looking at the part two, the part two matters, it's an interesting area now where you have, on the one hand, everyone agreeing that part two is fundamental to everything that happens in policies and objectives and when they're made and so forth, and in these they've already been considered, and in my submission they need to be considered at some point, and this is a plan change application. We are actually proposing a new objective as part of that that plan change application. But also, if there is agreement that the policies and the RPS and so forth have already addressed part two, then that has to mean something. You can't just tick it off and say it's been addressed so we can forget it forever. And in this case, you have a particular policy in the RPS that considers Section 6E. I accept that what you can't do is come up with a proposal and say, the policies, we don't like the policies, how they apply to this, so we're going to go to part two. And the case law's pretty clear you can't do that. But we've had a lot of discussion as part of this hearing about which of the policies in the RPS applies to this. Is it the very specific policy, which in my submission is relevant? It's a very specific policy, and that's referred to particularly in the Davidson decision, where it says, and I quote, King Salmon also states that when dealing with a plan change application, the decision maker must first identify those policies that are relevant, paying careful attention to the way in which they are expressed. Those expressed in more directive terms will carry greater weight than those expressed in less directive terms. And that, to me, seems to be pretty on point for where we are at the moment. But I also think that if you've got that weighting that's happening and everyone's agreed that part two has been taken into account when those policies got formulated, the way that they're expressed should be with a consideration to what was the meaning behind them. And I go no further than that. To clarify something that Mr. Winchester raised regarding the ancestral land and Mr. Mackenzie's and Ms. Connolly's evidence in chief was very clear on that point, that this was part of land that came back to them, and that their ancestors, some of whom are named in those streets made that painful decision after a lot of consideration that they would go down the development route in order to facilitate the economic and cultural well-being of their hapu more widely, and for that reason made the decision to develop off some of that land. And he talks about the way in which the hapu next door chose instead to go through and to go down the forestry route. So that was a decision that their forebears had made. They got back to that land when it was offered back to them from the Crown. And it was pretty clear in his evidence that it was considered to be ancestral land. And that's all I've got to say. Thank you.
Thank you very much. See if we have any questions for you. Poto, any questions? Stephen? So you thank very much. No questions in terms of what's been raised there. Just for the council, we've had a quick look at the delegation that was extended to us, and in the minutes recording that. And I just, either Dr. Ford or Mr. Winchester, I'd just have it in the back of my mind though, isn't there some restriction on the ability of a local authority to delegate the adoption of a plan document? Is there?
I think it's in clause 17, final approval of a proposed plan, if it's appealed. So, I mean, it'll be bound by your decision, but in terms of the decision to seal it with the council seal, that's a formality that needs to be gone through. It doesn't, I think, impact on the delegation for you to determine on the merits.
Right. Okay.
Does that make sense? Does that help?
Yeah, I just had a niggling worry in the back of my mind that other plan change hearings that I've sat on as a commissioner, we were only able to recommend, we weren't able to decide. And I just have an underlying, without going back and going trolling through the RMA, I just have a niggle in the back of my mind about that.
I thought that used to be the case because I also looked at this last week, and when we had a look at it and we had a look at the delegation, it is a delegation to decide. In some situations, there is the decision is just a recommendation that goes, and then there used to be a whole lot of stuff about when councils tried to fiddle with those recommendations, but this doesn't appear to be one of those. Oh, the other thing, if I can just, the quote I read out, in King Salmon.
Yeah.
That was King Salmon
Okay.
129.
Yeah. So, sorry, I thought you were looking at the Act for us.
Oh,
Yeah,
I was,
I
sir,
was.
sorry. Yeah, I think it's clause 17, and it's final consideration of policy statements and plans. And the constraint there is it's basically provides a window for minor amendments to be made, and then past the point of that, only the council can seal it as being approved.
Okay.
But I mean that is, dare I say it, genuinely a rubber stamping exercise, although there's not whole concept of a council seal these days is probably fairly old fashioned.
Okay, so our report Should be a decision report, not a recommendation report. And then the only challenge to that can be from submitters who have appeal rights. So was it, sorry to dwell on this, so was it just folklore that a council wishing not to run with the decision of a hearing panel such as this only really had the option to reconstitute a different panel and hear the whole thing again? I thought
I think it's changed.
it's
I
changed.
think it did used to be like that.
Sorry, I'm out of date, obviously.
Effectively, it's if the council does not wish to accept the recommendation
Or a decision though, isn't it? Because it's not a recommendation.
or a decision. But I mean, I would have thought the council's functus officio to the, because it's delegated that power to you. So I'm not aware of any case law whereby the council's withheld its seal under that clause 17 step and attempted to remake the decision.
I remember where it used to be. It was in the delegation section. Yeah, that you could only delegate.
The final approval of a plan cannot.
Yeah.
So that's a constraint on the power that can't be delegated. So I think it does line up to the delegations with these clear on its face. What do you think delegations do?
Yeah. Yeah, I just didn't want to get that bit wrong. All right, well, thank you very much for that, and that brings us to the conclusion of the hearing. I'd like to thank everyone for their input and their assistance. Given that there will now be no further written reply, the proceedings are, this stage of the proceedings are finished, and so now we'll go away and deliberate and then in due course issue our decision report. And and so Stephen or Poto, did you think one of you want to close with a karakia since we opened with one?
Well, kia ora tātou. Just thank you for your time and reiterate the Chair's good wishes and that. And so nei rā te mihi atu kia tātou. Let's close in prayer. I te atua ki atau I ho mai tō manaakitanga kei runga ki a mātou I tēnei ahi. O tira katukuna hoki te whakaaro ki a rātou e noho tō mahani I tēnei wā I raru te mau I tangi te rānei. Me te tūmina ko me te whakapono ka poipoi a rātou katoa e koe, ki paki te kaha, ki paki te ora. O reira uhi mai tō manaakitanga kei runga ki tēnei te tēpu, kia tutuki pai a mātou ngā mahi kai mui a mātou me ngā whāinga, ka whae e mātou katoa. Father, we thank you for the opportunity to be together today for these weighty deliberations and considerations. We spare a thought for those burdened by the trials and tribulations of life, that you can restore them to their former glory. And in closing, Lord, we just ask your blessings on this panel as we adjourn to deliberate, and wherever we land, it is going to be the best way forward for this area. Kia ora tātou. Me tino I ki roto I tingu tō mātou kai whakore kuraiti. Pai māriri. Kia ora.
Thank you.